You're listening to the Valley Current.
It's Tuesday, May 12th, 2026, and I want to welcome you to today's Deep Dive.
Glad to be here, as always.
Yeah, and we have a really incredible mission for you today because right now, inside a federal courtroom over in the Northern District of California, there is this trial happening that is basically mutating the psychology of a jury in real time.
Oh, absolutely. I mean, we are talking about the trial of the decade here. Elon Musk versus Sam Altman.
Right. And over the last 24 hours or so, it feels like the fundamental laws of legal gravity have just completely inverted.
They really have. It's fascinating.
Because usually, if you put a witness on the stand who has billions of dollars riding on the outcome of the case,
the opposing counsel just destroys them.
Exactly. I mean, the financial bias is essentially a weapon, right?
Right, yeah. The jury is basically instructed to ignore everything that witness says because their massive financial stake just, inherently compromises their honesty.
Right, but then yesterday happened. The defense in this trial brought out a literal parade of billionaires.
Yeah, people with just staggering financial exposure to the company.
And somehow, counterintuitively, that exact bias is currently saving the defense's entire case.
Which is wild. And, we're looking at a structural paradox here that you just rarely see executed this effectively at this level of corporate litigation.
Yeah, so let's talk about our source material for this deep dive because it really lays this out perfectly.
Right. So we are pulling from a really masterful piece of legal analysis from the spring 2026 volume of the Computer Law Group LLP newsletter.
Authored by their managing partner, Jack Russo.
Exactly. And what's great about this newsletter is it doesn't just, chronicle the day-to-day drama of the trial.
It strips away the drywall, basically.
Yeah, it exposes the absolute bleeding edge of the evidentiary architecture operating underneath the whole thing.
It really forces us to examine how human psychology actually processes conflicting motivations when, astronomical sums of money are involved.
And that's exactly what we're going to unpack for you today.
So to really grasp this, we have to establish the momentum of the courtroom leading into this week.
Right. Because over the past couple of weeks, we've been watching round 8 of the trial.
And in round 8, Musk's legal team constructed what the source analysis perfectly calls a witness wall.
Oh, a witness wall, yes. They brought in former insiders.
Like Mira Murati, Helen Toner, Colin McCauley.
Right. And crucially, these are individuals who have zero current financial stake in the ongoing entity.
Right. They are totally legally and financially disinterested parties.
And Musk's counsel utilized them to just ruthlessly attack Sam Altman's character.
Painting this picture of, systemic dishonesty and manipulation.
Yeah, and the tactical brilliance of round 8 was really its psychological simplicity.
Because by putting forward witnesses with literally no skin in the game, Musk's team eliminated the motive of greed entirely.
Exactly. I mean, if Mira Murati or Helen Toner get up on the stand and criticize Altman, a jury naturally leans toward believing them.
Because there's no obvious financial upside to their testimony, right?
Right. They aren't trying to protect a stock price or, secure some massive end-of-year bonus.
They're just former colleagues offering an assessment of their old boss.
Yeah, it creates a very clean, very compelling narrative for the plaintiff.
The jury just absorbs those attacks on Altman's honesty as these untainted, objective observations.
But then the calendar flips, right?
Right. We enter round 9, which just wrapped up late yesterday afternoon, Monday, May 11th.
And the momentum of the trial violently swung back to Altman and the defense.
And the crazy part is, they didn't achieve this by bringing in their own choir of disinterested saints to say, oh, Sam is actually a great guy.
No, they went in the exact opposite direction, which is so risky.
They allowed testimony from 3 current stakeholders who possess a concentration of financial bias that is it's unfathomable for a single courtroom.
We are talking about multi-billion-dollar exposures tied directly to the continued commercial success of OpenAI.
And the source material calls this maneuver the inverted witness wall.
Which is such a great term for it. It structurally mirrors what Musk did, but it relies on a totally different psychological trigger.
Right. So in round 9, you have Ilya Sutskever, Satya Nadella, and Bret Taylor taking the stand.
The co-founder, the CEO of the primary commercial partner, and the current board chair.
Between the 3 of them, you have hundreds of billions of dollars in corporate valuation and personal wealth just hovering over the witness box.
And in a standard legal playbook, this is a bloodbath for the defense.
Because opposing counsel usually uses the Federal Rules of Evidence. I think it's FRE 607.
Yes, FRE 607, which allows any party to attack a witness's credibility.
And FRE 611B, right?
Exactly, which governs the scope of cross-examination. They use those to systematically dismantle the witnesses.
Right. The goal is to point at the ledger, show the jury the billions of dollars at stake, and just invite the inevitable conclusion that the testimony is being bought and paid for.
Yeah, I mean, if your net worth goes to zero when the company loses the trial, why should a jury believe a single syllable coming out of your mouth?
The money is just this giant megaphone drowning out the truth.
But here is the doctrinal pivot that Jack Russo highlights, and it is a fascinating look at how legal rules intersect with raw human behavioral logic.
Okay, let's unpack this. What is the pivot?
When a witness with an aggressively documented multi-billion-dollar exposure to a company's success makes a concession on the stand that actively harms their own side.
Oh, wow.
Or, validates an argument made by their enemy, that financial bias doesn't neutralize the testimony.
It actually supercharges it.
Exactly.
Yeah.
The mechanism driving this phenomenon is rooted in the underlying logic of FRE 804b3.
Okay, wait. Walk me through 804b3.
Technically, in the Federal Rules of Evidence, this specific rule addresses hearsay exceptions.
Okay.
It's known as the Statement Against Interest Principle, or the Pecuniary Interest Reliability Principle.
Pecuniary interest, meaning financial interest.
Right. And the foundational theory of the rule is that statements contrary to a person's financial or property interests carry an inherent, almost unshakable reliability.
Because human beings are basically hardwired to protect their wealth.
Exactly. No rational actor willingly makes a statement that actively damages their financial standing unless the factual reality of that statement is so undeniable that they just cannot avoid saying it.
Right. They literally have no choice but to admit it.
And while FRE 804b3 is technically a rule about admitting out-of-court statements from unavailable witnesses, Russo's analysis points out something really smart.
Which is?
That the behavioral logic of it bleeds directly into how a live jury weighs trial credibility under FRE 401 and 403.
And those are the rules governing relevance and balancing probative value against prejudice, right?
You got it.
So what does this all mean for the jury? Let me put a mechanistic analogy to this so we can really see how the jury is processing this.
Yeah, go for it.
Imagine a notoriously harsh restaurant critic, okay? And this critic has a well-documented bitter feud with a specific chef.
Oh, I like this.
Right. So the critic goes to the chef's new flagship restaurant, and the review is exactly what you expect. It's brutal.
We hate everything.
Yeah, they write that the service was incompetent, the lighting gave them a headache, the management was a chaotic disaster.
Naturally.
But then, buried in the third paragraph, the critic admits, begrudgingly, that the tomato soup was structurally flawless and the best they've ever tasted.
Right.
Now, you, as the reader, you believe the praise for the soup entirely because of the hostility surrounding it.
Because the critic had every incentive in the world to lie and say the soup was garbage.
Exactly. The fact that they conceded the soup was incredible, despite their desperate desire to destroy the chef's reputation, makes that specific compliment totally bulletproof.
That captures the psychological mechanism perfectly. The hostility guarantees the truthfulness of the concession.
And in the Musk versus Altman trial, the jury is sitting through the legal equivalent of that soup review.
But the stakes are leveraged into the billions.
Right. When a witness stands up there, layered in financial conflicts and personal animosity, and still manages to admit something that provides a foundational block for the defense's argument.
The jury locks onto it.
Yeah. The very financial bias that Musk's team wants to use to discredit the witness ends up being the guarantor of the witness's honesty on that specific point.
And to really see this statement against interest principle in action, you have to look at the star witness of day 9.
Someone whose relationship with Sam Altman is incredibly complicated.
To put it mildly, we are talking about a man who authored the defining crisis of this company.
A man whose relationship with Altman is just fractured beyond repair and who is currently sitting on an unimaginable fortune.
Witness number 1 of the inverted witness wall, Ilya Sutskever.
Right. So Ilya Sutskever. Let's dig into his profile as presented in the newsletter.
So Sutskever operates as the analytical anchor for everything that happened on Monday.
He's a former chief scientist, a co-founder.
And arguably the most vital technical mind of the early OpenAI days.
But his financial posture right now, is just staggering.
Yeah, Jack Russo's newsletter cites the Bloomberg headline figure, which was actually confirmed under oath on the stand.
Sutskever currently holds a stake in the for-profit arm of OpenAI worth roughly $7 billion.
$7 billion.
And the newsletter pulls a critical temporal detail from Reuters that paints an incredible picture of the velocity of this wealth.
Oh, the appreciation timeline. Yeah, this is wild.
Back in November of 2025, that exact same stake was valued at roughly $5 billion.
Right.
Today, in May of 2026, it sits at $7 billion. That is $2 billion of appreciation in a matter of 6 months.
It's hard to even wrap your head around that kind of money.
So when Elon Musk's attorneys look at Sutskever, they see the ultimate FRE 607 target.
They see a man who cannot possibly be trusted to tell the truth about the company's origins because doing so risks a $7 billion lottery ticket.
Right. But the financial ledger only accounts for half of Sutskever's presence on that stand.
Yeah, the relational dynamics are equally intense, if not more so.
Because Sutskever has been profoundly estranged from both Sam Altman and Greg Brockman since November 2023.
He didn't just witness the board's attempt to oust Altman, he was the tactical architect of it.
The trial record shows he authored the 52-page memo delivered to the independent directors that served as the catalyst for Altman's sudden firing.
This is a man who systematically went to war with his own CEO.
And the defense lawyers for OpenAI made a highly calculated move on Monday. They didn't try to hide this animosity.
No, they actively surfaced the relational estrangement on the official trial record.
Why? Why do that?
Because they wanted the jury to look at Sutskever and recognize that this man is not here as Sam Altman's friend or protector.
They wanted the jury to see the hostility before the testimony even really got going.
Exactly, because the testimony itself was extraordinarily complex. On the surface, Sutskever delivered lines that Musk's legal team must have been absolutely thrilled to hear.
He was harshly critical of Altman, right?
Very. According to the direct quotes sourced via Reuters, Sutskever testified under oath that Altman exhibited a, quote, consistent pattern of lying.
Ouch.
Yeah. And he went further, stating that Altman was actively, quote, undermining and pitting executives against one another.
Which is a management style that Sutskever categorized as not conducive to any grand goal.
Explicitly including the safe development of artificial general intelligence.
Let's just isolate that moment for you guys listening. You have the co-founder of the company sitting in front of a federal jury, echoing the exact same character attacks that Mira Murati and Helen Toner leveled during round 8.
He is totally validating the plaintiff's core narrative about Altman's deception.
For Musk, this looks like a devastating blow delivered by an insider.
But then comes a pivot.
Right. Sutskever shifts from attacking Altman's character to discussing the structural reality of the company.
And this is where the defense extracts its miracle.
Because Musk's entire lawsuit hinges on a breach of charitable trust claim.
Right. Musk is arguing that OpenAI was founded as a nonprofit dedicated to humanity.
And that the pivot to a capped profit model was a betrayal born purely out of corporate greed and a desire to enrich the founders in Microsoft.
The entire premise of the lawsuit is that the for-profit turn was an illegal abandonment of the charter.
But Sutskever, under oath, dismantles that premise from the inside.
He explicitly confirmed to the jury that the early nonprofit donation strategy, like the idea that they could simply rely on the philanthropy of tech billionaires to fund their research, it had fundamentally and mathematically failed.
He testified that the strategy simply could not generate the capital required to secure the massive compute requirements OpenAI needed to survive.
Let alone compete in the modern AI landscape.
And we really have to understand what compute requirements means in this context because it is the engine of the entire conflict.
Oh, absolutely. We are not talking about buying a few extra servers for the IT closet.
No. Training frontier models requires tens of thousands of specialized GPUs running continuously for months.
Housed in massive data centers consuming the energy equivalent of, like, small cities.
The capital expenditure is just astronomical.
So Sutskever is telling the jury that the math of the nonprofit model was just broken.
No matter how noble the charter was, you cannot train an AGI on a bake sale budget.
Right. He admitted that the conversion to a for-profit structure was not an act of greed, but an act of absolute financial necessity.
And that concession is the ultimate statement against interest.
Because Sutskever hates the CEO. He literally just called him a liar on the stand.
He wrote a 52-page manifesto to get him fired.
Yet here he is, handing Sam Altman the exact structural defense needed to defeat Elon Musk's central claim.
He is validating the for-profit pivot.
Right.
But, let me play devil's advocate here on behalf of the jury.
Okay, let's hear it.
If I'm sitting in that jury box and I hear Sutskever call Altman a liar, but then suddenly defend the structural pivot that made Altman rich, I might just think Sutskever is a mercenary. I might think, sure, he hates his boss, but he isn't going to blow up his own $7 billion stake by admitting the company is an illegal enterprise.
That is a very fair point.
So how did the defense prevent the jury from dismissing the concession as simple greed? How do they prove he isn't just protecting his wallet?
Well, what's fascinating here is that the defense anticipated exactly that skepticism.
They saw it coming.
They absolutely did. And the specific piece of evidence they introduced to inoculate Sutskever against the charge of being a financial mercenary is brilliant.
What did they do?
They needed to prove his ideological purity. So during his testimony, they had Sutskever confirm a piece of his personal history.
Okay.
Early in the formation of OpenAI, he was offered a retention package by Google to stay there.
Right, and the value of that offer was roughly $6 million annually.
He turned down $6 million a year in guaranteed cash.
To go work for a scrappy nonprofit that had zero revenue model.
Exactly. And when asked why Sutskever testified, and CNBC captured this verbatim, he said, "I felt a great deal of ownership of OpenAI. I simply cared for it, and I didn't want it to be destroyed."
Wow. That drastically reshapes the psychological profile of the witness for the jury.
It changes everything. The jury is now looking at a man who demonstrably prioritized the mission over immediate, massive wealth.
A man who sacrificed millions early on just to build this entity.
So when a man with that specific history, who clearly despises the current CEO's methods, tells you that the nonprofit model had to be abandoned to save the entity from being destroyed,
the jury believes him.
Because he isn't defending the pivot because he is a greedy billionaire. He is defending it because, as the chief scientist, he saw the terrifying reality of the compute math.
A $7 billion stake hanging over him actually amplifies his credibility when he calls Altman a liar.
Right, because a mercenary would just keep their mouth shut and protect the stock.
Conversely, his intense personal hatred of Altman amplifies his credibility when he defends the for-profit pivot.
Because a bitter rival wouldn't hand the CEO a get-out-of-jail-free card unless it was the absolute, unavoidable truth.
Jack Russo's newsletter summarizes the duality perfectly. He says Sutskever's testimony was simultaneously the worst Sam Altman has heard on character and the most fundamentally useful he has heard on his structural defense.
Which means you're going to see both Musk's counsel and Altman's counsel quoting Ilya Sutskever in their closing arguments.
He gave both sides exactly what they needed.
Which is the hallmark of incredibly complex, highly credible testimony.
Okay, so Sutskever proves the need for massive funding to survive. And that creates this perfect, logical bridge to the second witness of the inverted witness wall.
Because if Sutskever identified the problem, witness number 2 is the man who actually wrote the checks to solve it.
We're talking about the CEO of Microsoft, Satya Nadella.
If Sutskever was the analytical and ideological anchor of Day 9, Satya Nadella was the structural heavyweight.
He represents the gravity of global enterprise.
Oh, totally.
So Nadella took the stand for roughly 2.5 hours of live testimony.
And to understand his presence in that room, you have to look past the individual and look at the ledger he represents.
Right, Nadella does not speak for himself. He speaks for Microsoft's staggering position within the OpenAI ecosystem.
The newsletter details that following the October 2025 recapitalization, Microsoft's position in OpenAI Group PBC is worth approximately $135 billion.
That equates to roughly 27% of the entire entity, $135 billion.
It is a level of financial entanglement that alters the atmospheric pressure of the courtroom.
When Nadella speaks, he is speaking with the weight of the most valuable software company in human history pressing down on his words.
And during those 2.5 hours, Nadella delivered what the source considers the most quotable, culturally resonant moment of the trial thus far.
It centers around a 2-word phrase: amateur city.
Yes. The context for this is the chaotic November 2023 weekend when the nonprofit board abruptly fired Sam Altman. Nadella was asked under oath to characterize that board's decision-making process.
And his response was devastating in its corporate dismissiveness.
He called the firing, quote, sort of amateur city as far as I'm concerned.
The newsletter notes that outlets like DNYUZ and Business Insider ran the slightly expanded version of the quote. I just felt like there must have been some amateur city as far as I'm concerned.
I mean, coming from the CEO of Microsoft, calling a board of directors amateur city is the corporate equivalent of a nuclear strike.
But why is this so legally critical for Sam Altman's defense?
Because it externally validates the core narrative of Altman's defense regarding that entire crisis.
Okay, explain that.
Well, Musk's team wants the jury to believe that Altman was fired in 2023 because the board uncovered deep systemic corruption and deceit.
They want the firing to be seen as a righteous act by a vigilant board protecting the nonprofit charter.
Exactly. But Altman's narrative has always been that the board was simply dysfunctional, paranoid, and incapable of managing a rapidly scaling enterprise.
So having Nadella, a man who commands a $135 billion stake and who had unparalleled visibility into the crisis, sit on the stand and brand the board as amateurs.
It crystallizes Altman's defense. It reframes the firing from a substantive indictment of Altman's ethics into a catastrophic procedural failure by a chaotic board.
But Musk's team wasn't just going to let Nadella lob insults at the old board and walk away, right?
Oh, definitely not. They used his presence on the stand and the massive discovery that came with it to drag the jury deep into the financial engine of the Microsoft OpenAI partnership.
And the internal documents they surfaced are absolutely mind-bending. Let's guide the listener through this math.
Yeah, let's do it. So the newsletter breaks down a specific piece of documentary evidence that really changes the complexion of the trial.
It's an internal Microsoft memo from January 2023, authored by Brad Smith, the president of Microsoft.
And in this memo, Smith models out the financial expectations for Microsoft's cumulative $13 billion investment into OpenAI.
Okay, so they put in $13 billion. What did the memo project as the return?
The memo projected a $92 billion return on that $13 billion layout.
A $92 billion return.
And the mechanics of that return are heavily specified. The model projected that the return would kick in with a 20% annual yield starting in the year 2025.
This wasn't some vague hope of future profitability. This was a hardened mathematical projection of aggressive yield generation by a corporate giant.
Furthermore, Musk's team reinforced this with a video deposition of Michael Wetter, played on Monday, which revealed that Microsoft had already generated approximately $9.5 billion in direct revenue from the partnership as of March 2025.
Wait. How does that actually work mechanically?
Yeah.
How is Microsoft pulling $9.5 billion out of OpenAI so quickly?
It comes down to the architecture of the partnership. Microsoft isn't just waiting for OpenAI to declare dividend.
Right.
They are taking OpenAI's foundation models and integrating them into the absolute core of Microsoft's revenue-generating products.
Oh, so like they are powering GitHub Copilot.
Yes, they are integrating it into Azure Cloud Services. They are embedding it into enterprise Office software.
So every time a Fortune 500 company signs an Azure AI contract, Microsoft is monetizing OpenAI's IP.
Exactly. The $9.5 billion is the tangible realization of that strategy.
So as a listener trying to follow the trial logic, I hear these numbers. A $92 billion projection, a 20% annual yield, $9.5 billion already pocketed.
Yeah.
It sounds like a massive victory lap for Microsoft. It sounds like the partnership is an unmitigated triumph.
Sure does.
How on earth does Elon Musk's team spin the most successful corporate partnership of the decade as a legal liability?
Well, that is the brilliance of Musk's litigation strategy. Microsoft's lawyers, during direct examination, absolutely use those numbers as a shield.
They look at the jury and say, the math vindicates the structure. We gave them the capital they needed to survive, and the results have been spectacular. The system works.
Exactly. But Musk's attorneys take those exact same financial exhibits, flip them over, and use them as a sword.
In their closing arguments, they will argue that the math is the structure.
The math is the structure, yes.
They will point to the Brad Smith memo and argue that a $92 billion return model with a 20% annual yield is the absolute antithesis of a charitable trust.
They will tell the jury, look at this document. Is this a charity trying to safely build AGI for the benefit of all humanity? Or is this a ruthless, highly optimized corporate asset designed to generate historic yields for Microsoft shareholders?
Musk's team weaponizes the success of the partnership to prove that the original nonprofit charter was utterly and completely subordinated to Microsoft's commercial greed.
The sheer scale of the success becomes the undeniable proof of the betrayal.
And to drive that narrative home, Musk's lead counsel, Stephen Mullo, introduced a piece of evidence that perfectly captures that specific anxiety.
It's an email from 2022 written by Elon Musk himself.
And it is perhaps the most resonant piece of written evidence Musk's team possesses. In the email, Musk writes, "I don't want to be IBM and OpenAI to be Microsoft."
That is such a loaded historical comparison.
Let's unpack the mechanism of that metaphor.
Yeah.
What is Musk actually afraid of in that COM22 email?
He is referencing the foundational dynamic of the early personal computer era.
Right.
In the 1980s, IBM built the hardware, the massive physical machines, but they allowed a tiny company called Microsoft to license and control the operating system, MS-DOS.
And eventually, the hardware became commoditized, and the software became the ultimate choke point of value and power.
Microsoft ended up dominating the industry while IBM was sidelined.
So Musk, looking at the OpenAI partnership in 2022, saw the exact same dynamic unfolding.
He saw OpenAI building the core intelligence, the operating system of the future, and he saw Microsoft aggressively wrapping their corporate tentacles around it, preparing to extract all the value.
Strategically, for the trial, that email is the cleanest, most verified evidence Musk has to demonstrate that it was Microsoft driving the hyper-commercialization of the technology.
It allows Musk to paint Microsoft not as a passive investor helping a charity, but as a predatory corporate puppet master pulling the strings.
Which perfectly reinforces the breach of charitable trust claim.
Exactly. Nadella's testimony provided Altman with vital procedural cover regarding the board firing, but it simultaneously handed Musk all the financial ammunition required to attack the structural integrity of the company.
So we have the $7 billion co-founder who hated the CEO but defended the math.
And the $135 billion partner who insulted the board but revealed the staggering financial projections.
That leaves the final stakeholder on the inverted witness wall, the man who represents the current board's defensive perimeter.
Witness number 3, Bret Taylor.
So Bret Taylor, the OpenAI board chair, took the stand late Monday afternoon. He served as the first official defense witness called after Sutskever concluded Musk's case in chief.
The newsletter refers to his appearance as a truncated opening because he basically ran out of time.
He's on the stand just long enough to inform the jurors that the company remains completely dedicated to its mission of saving humanity, and to describe the November 2023 ouster period as a dire situation.
The clock forced an adjournment, meaning he is scheduled to resume his testimony Tuesday morning today.
But even in that brief window, the legal mechanics of his presence were established.
And his financial bias introduces a completely different flavor of complication compared to Sutskever or Nadella.
Let's examine Taylor's portfolio. Bret Taylor is the chair of the OpenAI board, but his primary day job is running an AI startup called Sierra.
And according to reporting from CNBC and TechCrunch cited in the newsletter, Sierra just closed a massive Series E funding round.
A round led by Tiger Global and GV, which repriced the startup at a $15.8 billion post-money valuation.
$15.8 billion.
And the timing of this funding round is almost cinematic. The round closed on May 4th, 2026.
Exactly 1 week before he walked into that federal courthouse to testify.
You cannot script that kind of temporal proximity.
Now, Taylor's bias requires a more nuanced analysis under FRE 607.
Right, because unlike Sutskever, Taylor doesn't have a massive, publicly documented equity cross-holding directly in OpenAI.
He isn't a founder holding billions in direct stock.
And unlike Nadella, he isn't representing an external corporate investor holding a direct 27% stake.
But the conflict is deeply embedded in the architecture of his startup.
Because Sierra, his $15.8 billion company, builds its core products on top of OpenAI's foundation models.
Their entire commercial viability depends on OpenAI continuing to operate, innovate, and serve those models reliably.
Here's where it gets really interesting. Jack Russo's newsletter classifies Taylor's situation as second-order bias.
Second-order bias. Let's use a mechanistic metaphor to explain this to the listener.
Yeah, please do.
It's like a prominent real estate developer sitting as the chairman of the City Planning Commission. The developer doesn't actually own the city government, and they don't get a direct salary from the city budget.
Right.
But if the city suddenly stops paving roads or updating the electrical grid or issuing permits, the developer's entire private business empire collapses.
Their wealth is entirely contingent on the infrastructure they are supposedly governing impartially.
That is a brilliant way to conceptualize it. Taylor chairs the board of an entity valued near $1 trillion, while concurrently running a startup whose $15.8 billion valuation is structurally load-bearing on that entity's technology.
It is a profound, indirect conflict of interest.
And the source material highlights that Taylor is not ignorant of this dynamic.
No, back in February 2024, he made a public, documented commitment to recuse himself from OpenAI board decisions whenever there was a potential for commercial overlap with Sierra.
Which operates as a double-edged sword for his credibility on the stand.
How?
On the positive side, it demonstrates self-awareness and a commitment to governance hygiene. It shows the jury he recognizes the conflict and takes proactive steps to wall it off.
But on the flip side,
conversely, the sheer necessity of the recusal acts as an admission.
It validates the plaintiff's argument that his financial interests are so inextricably intertwined with OpenAI's operations that he literally cannot be trusted to vote on certain matters.
It reinforces the reality of the bias Musk's team wants the jury to see.
So, as Day 9 concluded, the jury had been battered by the gravitational pull of a $7 billion stake, a $135 billion stake, and a $15.8 billion startup valuation.
And the defense successfully utilized the inverted witness wall, using these deeply conflicted individuals to provide crucial structural cover for Sam Altman under the logic of the statement against interest.
It is a breathtaking high-wire act of litigation.
It truly is. But what makes Jack Russo's analysis so vital is that he doesn't just stop at the courtroom theatrics.
You're right. There's more happening beneath the surface.
The newsletter reveals that while the jury is absorbing all this emotional, high-stakes testimony, there is a silent killer working in the background of this lawsuit.
A silent killer.
That has absolutely nothing to do with whether Ilya Sutskever or Sam Altman is telling the truth on the stand, but it is quietly dictating the terms of the entire war.
Let's pull back the floorboards and examine this silent killer. We are moving away from the witness box and looking directly at the judge's bench.
The source details the foundational legal scaffolding of this case, specifically focusing on the statute of limitations architecture.
Because regardless of the momentum swings created by the witness walls, the judge has been systematically dismantling Elon Musk's original legal strategy through pretrial orders.
The structural advantage heavily favors the defense right now because pretrial orders 3 and 4 have gutted the most dangerous elements of Musk's complaint.
Let's trace the mechanics of this collapse. It started with pretrial order number 3, issued on March 31st, 2026.
This order eliminated Musk's continuous accrual theory.
Let's break down what continuous accrual actually means in a courtroom.
To understand continuous accrual, think of the mechanism of a monthly rent check.
Okay.
If your landlord illegally overcharges you on your rent and you pay it, that is a violation.
Right.
But when the next month rolls around and they overcharge you again, that new check constitutes a fresh violation.
Each check is a severable, independent obligation.
And each new check resets the statute of limitations clock for that specific overcharge.
So Elon Musk's lawyers attempted to apply this logic to OpenAI's operational structure.
They argued that every single day, OpenAI operated as a capped profit entity, generating revenue and serving Microsoft. It was committing a new, discrete violation of its original nonprofit charter.
They wanted to argue that the clock was resetting every single day.
Because if the clock resets every day, you can never be barred by the statute of limitations. You can sue them forever.
Exactly the strategy. But the judge explicitly rejected that application.
The court ruled that continuous accrual only applies to truly severable obligations, like our rent check example.
The transformation of a corporate structure from a nonprofit to a capped profit model is a singular foundational event, not a daily recurring obligation.
So the judge forced Musk to withdraw his continuing violation theory, entirely shutting off that avenue of attack.
That was the first severe blow. But then, on April 17th, 2026, the judge delivered pretrial order number 4.
Which was functionally fatal to the most explosive charges in the lawsuit.
The source analysis points out that while the judge avoided using the catastrophic phrase, directed verdict, the order backed Musk into an unavoidable corner.
It essentially forced Musk to elect whether to voluntarily dismiss his claims of fraud and constructive fraud.
The court signaled with absolute clarity that if Musk attempted to take those fraud claims to the jury, the judge was going to drop the hammer and apply a strict statute of limitations bar.
Recognizing the inevitable, Musk's counsel officially filed docket 485 on April 20th, voluntarily dismissing the fraud claims.
The fraud claims are dead. But we need to explore the why.
What is the specific legal mechanism that gave the judge the power to force that dismissal? Why did the clock run out on Elon Musk?
Jack Russo's analysis dives deep into the California discovery rule and concealment authorities that the defense utilized to build this trap.
The entire defense strategy anchors on a landmark precedent. Jolly v. Eli Lilly & Co.
Let's unpack the history and mechanism of Jolly. What does the rule establish there?
The Jolly case, decided by the California Supreme Court in 1988, dealt with a plaintiff who suffered injuries from a drug called DES, which her mother took during pregnancy.
Okay.
The plaintiff didn't immediately know who manufactured the specific pill her mother took, so she waited years to file her lawsuit until she felt she had enough concrete proof.
And what did the court say?
The Supreme Court ruled against her, establishing a brutal but essential standard for the statute of limitations.
The rule is simple. So long as a suspicion exists, the plaintiff must go find the facts. She cannot wait for the facts to find her.
You cannot sit back and wait for the smoking gun to arrive in the mail.
You cannot. The law dictates that the statute of limitations clock starts ticking the absolute millisecond you have a reasonable suspicion of wrongdoing.
You don't need all the evidence. You don't need a confession. You just need to suspect you have been wronged.
Once you have that suspicion, the burden is entirely on you to initiate legal discovery and hunt down the facts.
The newsletter notes other supporting precedents, Snap, Mangini, Bernson, which all reinforce this doctrine.
Even if a defendant engages in complex concealment to hide their actions, if the plaintiff is placed on notice of a potential claim, the clock is running.
And this brings us to the devastating aha moment of the entire pretrial phase.
Right, because the piece of evidence that triggered this Jolly doctrine and destroyed Musk's fraud claims wasn't uncovered in some encrypted internal OpenAI server.
It wasn't found in a leaked email from Sam Altman.
The lethal evidence was provided by Elon Musk himself.
It was an entirely self-inflicted wound.
Explain how that happened.
The court reviewed a transcript from a deposition Musk gave almost a decade ago in 2017.
In that sworn testimony, discussing the early dynamics of OpenAI, Musk explicitly stated under oath that he, quote, started to suspect that he was being swindled and that he felt he was being tricked.
He used the exact word swindled in 2017.
The moment the judge saw that word in a sworn transcript, the legal calculus was finished.
Because under California law, the statute of limitations for fraud is 3 years.
Because Musk admitted he suspected he was being swindled in 2017, the Jolly rule engaged immediately.
The 3-year clock started ticking in 2017 and definitively expired in 2020.
4 full years before he finally filed the federal complaint against Altman in August of 2024.
The clock had expired long before he ever drafted the lawsuit.
And what Jack Russo emphasizes is the cascading effect of this failure.
The claims that remain alive in the trial today, the breach of charitable trust and the unjust enrichment claims, do not benefit from the discovery rule extension that theoretically could have saved a fraud claim under different circumstances.
By establishing the 2017 suspicion, the foundation of the entire lawsuit has been drastically narrowed.
The defense successfully used the architecture of time to shield the company from the most damaging accusations.
So, the silent scaffolding of the law has protected OpenAI from the existential threat of a massive fraud verdict.
But even with that protection, and even with the brilliant execution of the inverted witness wall in round 9, the mere continuation of this trial is projecting a massive shadow over the real-world operational future of the company.
Which brings us right back to the courtroom today. Tuesday, May 12th, 2026. The day the newsletter defines as the Tuesday binary.
We have reached the climax of the liability phase. The structure of today's proceedings offers no middle ground.
Bret Taylor is scheduled to conclude his testimony at 8:30 a.m. Pacific time. And the moment he steps down, Sam Altman takes the stand.
Jack Russo's framing of this as the Tuesday binary perfectly captures the precariousness of the moment.
The momentum swing achieved by Sutskever and Nadella on Monday is fragile.
It is entirely dependent on how Altman handles his cross-examination today.
Let's look at the mechanism of that cross-examination. Musk's lead counsel, Stephen Mullo, is going to utilize FRE 608B.
Let's explain how 608B functions in a hostile cross-examination setting.
FRE 608B is a surgical tool. It allows opposing counsel to interrogate a witness about specific, discrete instances of past conduct that directly reflect on their character for truthfulness or untruthfulness.
Mullo is not going to stand up and ask a vague philosophical question like, Sam, are you an honest person?
No. He is going to produce the 52-page memo drafted by Ilya Sutskever.
He's going to read aloud the specific, detailed allegations of manipulation provided by Mira Murati and Helen Toner during the Round 8 witness wall.
He is going to isolate individual moments in time and demand that Altman, under oath, explain those specific episodes of alleged deceit.
And the binary nature of the day rests entirely on his responses.
If Altman can navigate that minefield, if he provides clean, highly specific, non-evasive answers,
and successfully frames those episodes as complex management miscommunications or difficult strategic judgment calls rather than calculated lies, he wins the day.
he consolidates the massive structural gains provided by Nadella and Sutskever on Monday, locking in a defense-favorable narrative for the jury.
But if he falters under the pressure of 608B,
If he stumbles, if he attempts to evade the specifics, or if Molo manages to trap him in a verifiable contradiction regarding one of those specific instances,
the entire architecture of the defense collapses.
the Round 8 witness wall is instantly resurrected in the minds of the jury.
All the character damage inflicted by Murati and Toner rushes back in, and the structural concessions extracted on day 9 evaporate.
It is a pure, high-stakes binary outcome.
It is going to be a masterclass in psychological endurance.
But we need to zoom out from the courtroom for a moment. For you, the listener, analyzing this, we have to ask, outside of the immediate legal jeopardy for Sam Altman, why should you care?
What is the actual, tangible, real-world application of this Tuesday binary?
Why does the broader financial ecosystem care so deeply about what an advisory jury decides in a federal district court?
The downstream consequences of this trial are tectonic, and they all converge on a single monumental financial event, the IPO.
OpenAI's initial public offering.
Yes. The litigation is generating a dense cloud of structural uncertainty.
And if there is one thing institutional markets despise more than bad news, it is unresolved structural risk.
The newsletter highlights some deeply tense behind-the-scenes reporting from the Wall Street Journal regarding the internal financial posture of the company.
According to the reporting, OpenAI's chief financial officer, Sarah Fryer, has privately advocated for delaying the company's highly anticipated IPO, pushing it from the fourth quarter of 2026 into sometime in 2027.
Delaying what is arguably the most significant public offering of the decade.
Because, as she reportedly cautioned internal stakeholders, the entity is simply not yet mature enough to meet the rigorous, unforgiving reporting and disclosure standards required of public companies by the SEC.
And the ongoing trial is massively exacerbating that immaturity.
Let's explain the mechanics of an S-1 filing, which is the foundational document a company must file before going public.
It includes a massive section dedicated entirely to risk factors.
And that is where the trial becomes a poison pill. Imagine being an institutional investor, a major pension fund, or a sovereign wealth fund, reading the S-1 prospectus for OpenAI.
If this trial results in an adverse advisory jury finding on the breach of charitable trust claim, that finding must be prominently disclosed in the risk factors.
The prospectus would essentially have to state, a federal jury believes our foundational corporate pivot was an illegal breach of trust.
That kind of disclosure paralyzes institutional capital.
You cannot ask Wall Street to invest hundreds of billions of dollars into an entity whose very right to generate profit is actively disputed in federal court.
Now, the source material does note that OpenAI and Microsoft recognized this massive disclosure risk and attempted to execute a structural cleanup right before the trial began.
On April 27th, 2026, they officially amended their core partnership agreement.
It was a highly calculated maneuver designed entirely for the consumption of future public markets.
They removed the famously controversial AGI clause.
The AGI clause being the provision that tied certain massive IP rights and commercialization milestones directly to the moment OpenAI successfully developed artificial general intelligence.
Exactly. They stripped that clause out entirely and replaced it with a much more conventional mechanism, a fixed-date intellectual property license expiring in 2032.
Why execute that specific swap just weeks before trial?
To eliminate a massive, unquantifiable variable from the eventual S-1 filing.
Wall Street analysts cannot mathematically price a nebulous milestone like achieving AGI.
It is a philosophical concept as much as a technical one. No one knows exactly when it happens or who defines it.
But Wall Street absolutely knows how to build a discounted cash flow model around a fixed-date IP license expiring in 2032.
The amendment was an attempt to make the deeply weird, hyper-futuristic structure of OpenAI look like a normal, predictable enterprise software company.
It was an exercise in financial domestication.
But even with that elegant contractual cleanup on April 27th, the structural risk introduced by Elon Musk remains active.
The liability phase of this trial concludes on May 21st, just over a week away.
The remedies phase, where the actual consequences are determined, and the closing arguments commence the week of May 18th.
The entire technology sector is holding its breath.
Because within a matter of 9 working days, the advisory jury will deliver its verdict.
And the executives drafting that S1 prospectus will finally know whether they are inheriting a cleared runway or a legal catastrophe.
To summarize the incredibly dense journey we have navigated today, we began by exploring the counterintuitive psychology of the inverted witness wall.
Analyzing how the defense weaponized the testimony of 3 heavily conflicted stakeholders, Ilya Sutskever, Satya Nadella, and Bret Taylor.
We saw how the doctrine of the statement against interest allowed Sutskever's $7 billion stake and deep personal hostility to actually amplify the credibility of his defense of the for-profit pivot.
We examined how Nadella's $135 billion presence allowed him to unilaterally dismiss the November 2023 board as amateur city,
while simultaneously providing Musk with the devastating $92 billion return projection needed to argue that Microsoft's financial math fundamentally cannibalized the original nonprofit charter.
And we exposed the silent legal scaffolding of the statute of limitations, tracing how a single word swindled spoken by Elon Musk in a 2017 deposition triggered the Jolly precedent,
effectively dismantling his most dangerous fraud claims before the trial even began.
It has been an absolute masterclass in the intersection of litigation tactics and human behavioral psychology.
But if we connect all of these tactical maneuvers to the bigger picture, it raises a profound structural question that extends far beyond the fate of Elon Musk or Sam Altman.
Look at the specific entity at the epicenter of this conflict, OpenAI Group, PBC.
You have a hybrid public benefit corporation nested underneath a nonprofit 501c3 parent board, financially entangled with a $135 billion commercial partner in Microsoft, all of them racing to construct trillion-dollar artificial intelligence infrastructure.
It is a corporate Frankenstein.
It is unprecedented. And the provocative thought we have to leave you with is this. When hybrid experimental corporate structures of this magnitude collide with the raw gravitational pull of trillion-dollar tech ambitions, is the traditional, centuries-old legal concept of fiduciary duty fundamentally broken?
Are we watching the American legal system fail in real time on a public stage to categorize and govern the actual messy, hyper-capitalist reality of modern AI development?
Can the idealistic charter of a nonprofit possibly survive contact with a meticulously modeled $92 billion return projection?
That is the exact question the jury is wrestling with today, and it is the question the entire global economy will have to grapple with for the next decade.
Thank you for joining us on this deep dive into the legal architecture of the Musk v. Altman trial. We encourage you to keep exploring the mechanisms behind the headlines, keep analyzing the underlying structures of the companies building our future, and above all, keep questioning the narratives you are handed.
Until next time.
Tune in next time on The Valley Current.